Consumer Counterpoint. I'm Christine Argentine of Cypher Shaw, one of your hosts.
And I'm Paul Yovanik, also hosting the Cypher office in Chicago.
So today we're talking about something that we've talked about before in a slightly different context, but I think it comes up pretty often in the consumer class action world, in the employment world too. And we've seen a lot of courts dig in on it a little bit more specifically over the last several years, and that's arbitration provisions.
Right. And, previously we talked about, do you even want arbitration? If you do, what does it look like? And what are the pitfalls or what are the considerations? We kind of had, almost like a three-part series. I think this really kind of fits squarely into the discussion that we had previously. All right, now you want arbitration. What do the terms look like? How do they play out? And we saw that play out a little bit recently in a Ninth Circuit oral argument, questioning some of a company's terms and policies in their arbitration provision.
Yeah, and in a slightly different way than we've talked about before,
Right.
and we typically see. So what we typically see is courts really digging into what did that arbitration provision look like? Where was it? Right? Did it truly
broad
put
enough?
someone on notice? Yeah. Does it include the dispute? That's
Exactly.
right. Here, the oral argument in the Ninth Circuit was really on two specific points. One being unilateral modification of that arbitration provision.
Right.
And two being on the delegation of the authority to decide whether a matter is arbitrable.
Yes.
Giving that to the arbitrator as opposed to the court.
Because I think for years that was always kind of the easy thing, I think, for businesses to say we're going to compel arbitration, and really there can't be an argument before the court because that's not for the court to decide.
Right.
And so now we've seen and we saw it here in this Ninth Circuit oral argument, the court's really pushing back on that and being very critical of that type of language.
Yeah, and in fact the Ninth Circuit was saying this is clear, right? This is clear law based on a U.S. Supreme Court decision that came down in 2024, basically saying this is about contract formation. This is about assent to the terms of a contract, and that's for the court to decide.
Exactly. And so, seeing that, I mean, it could be a question of whether or not policy, arbitration provisions need to continue to be, reviewed, revised, updated, because this is certainly something that's been clear all the way from the U.S. Supreme Court.
Yeah. And I think, it makes a lot of sense, right? And we see a lot of courts, even if there is that provision, dig into, did the parties consent to this arbitration provision? That's kind of everything we were talking about before in terms of, was the language present? Did the plaintiff really see and review and understand that provision? So they've been doing this, but I think what's interesting about the Ninth Circuit opinion is the court is, as you said, very critical of the company for even having what they deem an illegal provision in their arbitration provision.
Right, and you're absolutely right. I mean, we've seen it, we've experienced where we had similar provisions over the years in courts saying, yeah, I know that's there, but this doesn't make sense, or like on its face, it just does not make clear that this is something that is arbitrable, and so we saw it, and then Supreme Court weighed in 24 and kind of confirmed that,
right?
And so that is a very interesting thing to be coming up in 2026.
Yeah. So bottom line on that one, right? Review your arbitration provisions, right? The decision of whether or not to arbitrate a dispute is a court's decision.
Yep.
So to the extent you do have provisions in your arbitration provision that say that is for the arbitrator to decide, we should be removing those, right? Yep. Those are no longer enforceable. We want to take those out. And as you said, this was a very common provision for many, many years.
Yeah.
So if you haven't reviewed your arbitration provisions in a while, it might be there, and we just want to make sure we're updating those.
It was just one of those easy threshold issues to say, we're out of court because you don't even have to decide, Your Honor, anything regarding this arbitration provision other than the fact that there is one.
Right.
And then if an arbitrator decides that he or she wants to bounce it back, that's for that arbitrator to decide, but not the court.
Right. So that takes us to kind of the second piece of this oral argument and what was really at issue here, which is, are is a company's ability to make unilateral changes to their arbitration provision in this instance, but generally to their terms of use, anything that's going to be binding on that individual. Can they do that unilaterally? And if they do, is that illusory?
Yeah, especially where it's, the unilateral change without notice, and that's kind of what we
Right.
saw in this oral argument, where the courts were, really critical again of this idea that a company can just make changes to its terms of conditions and not notify anybody and say, but you're bound to the terms that you
Right.
never saw. I mean, it's a very, it can be somewhat straightforward when you think about it,
Yeah.
at 30,000 feet. You're like, how do I know that I don't, what I can and cannot do if it's
Right.
being changed in the middle of the night?
It's a basic principle, right? The trickier part comes in when you need to really think through how are you trying to enforce this arbitration provision?
Yes.
And so if I did send notice, what did that look like, and was it sufficient for this particular context or that particular context?
Right. And we see it in different contexts, and we see it play out, different types of privacy claims. But if all you have are emails, but it's something related to text messages or phone calls, and you don't have a user's email address, how are you sending notice? You should be expanding the notice to go out to text messages
Right.
and phone numbers, because if that's how you're trying to enforce and put someone on notice, we've made a change to our terms of use. Because the first thing you want to be able to argue, or the first thing the plaintiff's going to argue, is, how did I know
Right.
that I didn't agree to this, because I never knew about this? I continue to use the website, but I don't. Users. I think the easy argument is users just don't go to the terms of use every time they go to a company's website.
Right. Right. I mean, and that's, so you brought up the TCPA context,
Yeah.
right, where you're sending text messages, and if the only way you're communicating with that individual is by text message, that notice should go out by text message. Hey,
Right.
we've changed our terms of use, and by, you are agreeing, by continuing to receive text messages from us, you're agreeing to those changes.
Because I think it goes back to what you're saying about purpose and what you're trying to accomplish. And if you're trying to accomplish arbitration for, let's say, in the TCPA context, and you have phone numbers, sending users and customers whose email addresses you have that you changed it, yeah, that'll cover a small, not maybe a small, but like a group of people, but not all of them, because some people, the way that they opt into receiving text messages and communications by SMS might not involve an email address, and if it doesn't, then there's a pocket of people that you're missing.
Right. Right. And then you just brought up websites, right? So that's something that we talk about a lot on this
Yeah.
video cast, is kind of that new trend of cases where you've got the pixel cases, or even cases involving someone, using your website and checking out or making a purchase. And so thinking through where they are agreeing to the terms of use to the extent you have an arbitration provision that you want to enforce. So checkout, pretty easy.
I was gonna say checkout is easy. You have them check that box right there, and so you know that the most recent, at that time, terms and conditions are being accepted at the time that they click submit for their order. That's great.
Right.
But what about the browsers? What about the people
Yeah.
that are just working around the website?
It gets a little trickier, right?
does.
Now we know, and we've been talking about cookie banners and putting up cookie banners to make sure individuals are consenting to the use of technology where data is being sent to third parties. And oftentimes those cookie banners say, you're agreeing to the terms and conditions, you're agreeing to the terms of use and the privacy policy.
Right.
Probably sufficient, right? What happens when you accept those cookies or even decline those cookies, and now that pop-up isn't happening
You don't
anymore?
see it. Yeah. Exactly.
Right? So, do we have the answer to that? Not necessarily, right? It's a bit of a business decision. Could you have another pop-up once you change those terms and conditions that says, hey, we've changed our terms and conditions by continuing to use our website, you're agreeing. But I think the question there becomes, well, how long do you have to have that pop-up
Right, because
effective?
you don't know when a user's going to go, or a customer is going to go back on the website, and so you don't know, and what does that pop-up look like? Obviously, and something we talk about with clients all the time is the intrusion on the websites, and because obviously the sales side and the
Right.
business side, is sometimes different than the legal side. And it's like, legal would say, oh, maybe we should have pop-ups for everything, and the business side saying, yeah, but we're trying to get people to be interested in going to our website and not have to click 7 times to just get to the home page. So there's got to be that balancing act of what does it look like, and I think it's a case-by-case basis, client by client, as we look through that stuff of, maybe we can get away with a few more pop-ups or an extra pop-up there, and then other times I think we have to be a little bit more strategic because we're trying to be, the least invasive as possible.
Right.
For the particular customer base.
Right. How are we affecting consumer experience? With websites too, you have to think about what page are they coming in on, and does that pop up, right? So because sometimes you can navigate to a sub page without going to the home page, and making sure that those notices, those disclosures are appearing whenever someone accesses your website.
Right, because sometimes if you use a search engine, it'll show you like the main homepage link and then a couple sublinks underneath, and if you click that sublink and you bypass the homepage and you don't get notice of the updated terms, there could be issues.
Yeah.
And so I think that's something definitely important to figure out how they're accessing the page. Is there ways that we can make sure that they're getting noticed? Again, it's just, courts are, we've talked about this with tons of other privacy statutes. Courts are always looking at, the transparency and whether or not a user, a customer is on notice of their rights and what they're agreeing to do. Because again, the Ninth Circuit has made clear, and very skeptical of a company's ability to change things in the middle of the night and say, now you're bound by those terms that you had no idea about.
Right. And I think from a business's perspective, right, making sure you are keeping records of when those changes are happening, how you are sending out those notices, so that if you find yourself in a situation where you're trying to enforce that arbitration provision, you have clear records showing this is the change we made, this is the date we made it, this is the date this particular plaintiff would have seen it, right, was put on notice that this change was made. And so, of course, it's something that, we are always trying to have our clients think through, into the potential risk of litigation and what that will look like and how you're going to prove it.
Yeah, and it kind of just goes back to the idea that it's not just so simple just to throw an arbitration provision up there. Just, weave it into the terms of use, because, again, there's a lot of questions involved, because the idea is to get, whether it's certain claims, all claims, into arbitration, and if that's the goal, other questions need to be asked, and we need other answers to make sure, are we accomplishing, is the business accomplishing what it's trying to do with this provision?
Yeah. So, of course, this was just an oral argument, no telling what the Ninth Circuit decision will actually be, but, seemed pretty clear where the judges were headed on this one, given the precedent and given the issues in this particular case.
I think I'd be surprised if they came out a different way, just with how critical and some of the sound bites that we saw and read based on that oral argument. I just think that it's again, as we started out with, this is just a kind of putting companies on notice of, be aware of what's in your arbitration provisions so you don't end up on the wrong side of a challenge like this.
That's right.